Good morning, you're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder, Mr. Rojas told me this morning that you have the intention of trying to hire an attorney.
Yes, ma'am.
Okay, so I need you, if your family or you is going to do that, I need that done within the next 30 days.
Yes.
I'm gonna reset your case one time. Obviously, I can't have you just sitting in jail while we're not doing anything on your case.
Notice how the judge wastes no time setting clear boundaries. She's giving the defendant exactly 30 days to hire a lawyer. In real courtrooms, this kind of reset is a lifeline, but also a warning shot.
And so Mr. Rojas will remain your attorney until or unless you hire someone. If for some reason it doesn't work out that you hire someone before that next court date, then we're gonna move forward with Mr. Rojas, okay? Okay, you can go back with the bailiff. Thank you. Ms. Pratt? Ms. Pratt, come up, please. Ms. Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I have the patch, because I found out that I have a tumor in my kidney
Okay.
while I was in jail, so that's why I can't urinate.
Wait, she says she can't provide a urine sample because of a kidney tumor? The courtroom tension spikes here because the judge has heard this excuse before, and she's not buying it.
Okay. Because I have notification,
The lady came from Vienna to put the patch on. It was real late at night in jail.
so I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what I don't have, that's not true. So I'm going to
I
find,
had the paper at home. I didn't bring it with me.
well, you didn't show up yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks.
Right.
You change it.
Yeah,
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
you being in the parking lot doesn't do any good because I'm not in the parking lot, am I?
Right?
Okay.
Yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your
I
chair.
have been up all night crying.
Okay, I'm going to raise your bond this time for violating your
It's the judge's tone shift.
your condition
She's
of
connecting
your
the
bond,
dots,
that you have
missed
a
drug patch, no
and have it
paperwork, and
changed every
possible
2 weeks
impairment
the
in court.
appropriate way. I'm going to raise
This
your
isn't
bond
just
to
about procedure
$20,000.
anymore, it's about
Condition of that
credibility.
bond, your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You can go back with the bailiff. Good morning, sir. Are you Robert Hebert? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hebert, in cause number 25 DCCR 0740, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements from February 11th of 2025. And how do you plead to that charge?
Okay.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Because you do what they charge you.
Okay. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
The paperwork on the tablet, did y'all go over it? And do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
That's correct.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection?
It's admitted. Is there any evidence that Mr. Hebert is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections.
That's a guilty plea sealed. 2 years for failure to comply with sex offender registration. Quick note. Texas law treats that as a third-degree felony, meaning up to 10 years, but plea deals often land on the lower end like this.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. See, Brandon Henderson.
Judge, you could.
I don't know. They'll tell you. They'll tell you.
Good morning. Are you Warren Mills?
Yes, ma'am.
Will your client waive the formal reading of the indictment?
Anyway, Your Honor.
Mr. Mills, in cause number 25, DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer from November 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the
Yes.
state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
I understand.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am, I understand.
State tenders number
No
1.
objection?
It's admitted. Any evidence that Mr. Mills is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of that plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices
Yes, ma'am.
qualify. I have to read the whole thing to you.
Oh, yes, ma'am.
That's okay. That's okay. And see, now I'm going to mess it up because I got. No, you're fine. You should just. That's okay. Just read it to make sure you understand what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Just for the record, Judge, I believe Mr. Nichols has agreed to dismiss his misdemeanor case in County Court 2.
We have.
Okay.
Okay, then I'm sure Mr. Nichols will take care of that, and they'll that way you'll be able to not have that holding you out there anymore. Okay.
Okay, that's good.
On that.
All right.
On that.
Good luck to you, sir. You can go back with
Thank
the
you very
bailiff.
much.
Good morning, sir. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp, in cause number 25, DCCR 0916, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025. The indictment alleges you were previously convicted of theft, a third-degree felony, January 20th of 1987. Also on that same date, aggravated robbery, a first-degree felony, And after those were final, you were convicted of possession of a controlled substance, a second-degree felony, October 9th of 1998. What that means is that if you go to trial in this case and you're found guilty and those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0917, you're also charged with a second-degree felony offense of aggravated assault with a deadly weapon. Those same prior offenses are listed in that indictment as well, again, making this, for punishment purposes, if convicted, a habitual offender status, which means minimum 25 up to 99 years or life in prison. Do you understand?
Look at this. Because of his prior felonies, the judge warns him he's facing habitual offender status. Translation: minimum 25 years up to life. That's courtroom reality hitting hard.
In each of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter pleas of guilty in your cases, to proceed on, I guess that would be count one only.
Yes, Your Honor.
So just the offense, not the underlying prior offenses. So go on count one only for a 15-year term in the institutional division of the Texas Department of Corrections. You've got every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter pleas. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Sharp, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Sharp, we will appoint someone today. They should be able to see you very soon to begin preparation for trial.
Yes, ma'am.
So talk to that attorney and they'll file the appropriate paperwork, and then as soon as they do that, I will set it for a hearing on a bond, okay?